You really get the sense that he feels like he's the smartest person in the room, in that city, on the planet. And that if only everyone would just sit down and listen to him, he could explain this whole unfortunate mess and how he had nothing to do with it. The murder trial of Vegas politician Robert Tellez turned from the bizarre to the surreal as the defendant took the stand in his own defense to testify in a rarely seen narrative form. Plus, documents filed last week argued that family matriarch Donna Adelson should have her case dismissed because the prosecution took too much time to bring charges against her for her role in the murder of Florida State University law professor Dan Markel. All this and more this week on Courtroom Confidential. Hey everybody, it has been an absolutely wild week for a couple of reasons. One, we're about to talk about some testimony that you never see. I've been doing this for a long time. I try to not use absolutes, but you never see a defendant testify in this manner. And that's what we're going to talk about this week. And another thing is, usually a lot of these arguments that defense attorneys make ahead of time, I'm willing to admit this, asking for a case to get dismissed, are dismissed by the judge out of hand. But this week, we're going to talk about an argument that just might have some teeth. So let's jump right in. Former Vegas area politician Robert Tellez took the stand in his own defense on Wednesday and Thursday. Tellez is accused of murdering investigative journalist Jeff German, who was found stabbed to death outside his Las Vegas home in 2022. "This is the day I've been waiting for," Tellez said after his attorney received permission from the trial judge to allow his client to testify by way of narration instead of a standard question and answer form. "Unequivocally, I'm innocent," Tellez said, speaking softly and turning in the witness box to face 12 jurors and 2 alternates who each leaned forward to face him. Some held notebooks, pens poised, according to courtroom reporters. The hushed courtroom was packed with media and spectators, including several members of slain reporter Jeff German's family. "I didn't kill Mr. German," Tellez said. "When I share an opinion with you, that's my right, and it's your right to decide whether you want to doubt my opinion or not. I'm just hoping that I'm not stopped from sharing with you what I have to say." So began the first 90 minutes of Tellez's testimony. However, it was not anything that could be described as smooth sailing. Within 30 minutes, after starts and stops and fumbled impromptu directions to court staff to show photos and documents, some jurors were glancing around the courtroom. Some notebooks were down. One man twirled his pen between his fingers, according to reports from inside the courtroom. Prosecutors have argued that Tellez killed German because German authored articles for the Las Vegas Review-Journal about a county office in turmoil under Tellez's leadership, including allegations that Tellez had an inappropriate relationship with a female coworker. Evidence has shown that Tellez's DNA was found beneath German's fingernails and that Tellez had family ties to a maroon SUV seen in German's neighborhood at the time German was killed. Trial is expected to conclude after Tellez's testimony, with closing arguments as early as late this week or early next. All right, well, what's happening here? First, and I cannot stress this enough, the idea of a defendant taking the stand to testify in what we call the narrative form or testify by narration is incredibly rare. I was sitting here as I sat down to record this episode trying to think if I've ever seen that in my own career myself. Certainly not in a trial that I've ever directly handled. I think I can remember one instance involving a misdemeanor case where the defendant had mental health issues, where his attorney just simply had no choice but to allow him to testify, as is everyone's constitutional right. And because he knew that what was going to come out of his mouth was going to be, at best, peppered with reality and truth, he allowed him to testify in the narrative. And that brings me to my point as to why it is so rare. Usually you have an attorney. Your attorney walks you through the facts of your testimony, what you have to say, by asking you questions as if you were any other witness. And then you're cross-examined. Because an attorney not only has a duty to zealously advocate on behalf of their client, but they also have a duty to be truthful themselves, a duty to the court, an ethical duty to preserve their own bar card. that says that they will not suborn perjury. And that means that they're not going to willingly and knowingly lead a person through a narrative that they know to be entirely false. Now, in this instance, that has not been said. Tellis's defense attorney has not stood up in front of the court and said, I know my client's going to lie, so I don't want to be any part of it. None of this is explained to the jury, by the way, but I am sure there were some conversations that took place, perhaps in chambers or at sidebar, that weren't in open court, where this may have been discussed, that Tellis intends to testify and his attorney intends to allow that only by way of narration. That signals to everybody in the know that what this man is about to say is either something that his attorney doesn't agree with because it doesn't deal with reality, or he knows he's actually going to perjure himself and doesn't want to take part in that. Even if he felt that his client was going to say some radical things, but those things weren't flat out provable lies, you may see him just go ahead and walk him through that testimony. It's every defendant's prerogative to say what his theory of the case is. And it's not up to an attorney to say, that's a bad theory, therefore I'm not going to sign off on this. This is something very different. This is something about truthfulness and about whether or not perjury is going to take place. Tellis took an oath and he's swearing to tell the truth. And as an attorney, you cannot suborn what you know to be false testimony. And so I think that's what's taking place here, though the judge, rightfully so, will never explain that in court and will never explain that to the jurors. And the jurors are just going to wonder, why has this man been talking to me straight to my face and telling a story without anybody leading him through it? So very bizarre, very incredible to watch. I did, if you're very interested in this, an entire live reaction to his testimony that you can find on this channel. And it is fascinating. There are points where it's boring because he's walking through a lengthy dissertation about probate law. But even that is somehow fascinating when you realize the other thing I want to talk about, and that is what a narcissist this man is. When I watched that testimony, this did not appear to be a man who was pleading for his own innocence, who was pleading for his life, who was saying, I've been falsely accused of murder, ladies and gentlemen. I've been accused of the worst thing that you can be accused of. And I'm standing here now to testify on my own behalf and tell you that that is not true and that did not take place. That was not the person I saw testifying. The person I saw testifying was someone who was very happy to have a captive audience and wanted and loved hearing himself speak. That's what I saw, the person I saw testifying. His entire demeanor oozes this sense of entitlement, and it's untethered to reality. And it's so bizarre because it's so fascinating, because you really feel, I mean, he's very polite. He's polite to courtroom staff, but you really get the sense that he feels like he's the smartest person in the room, in that city, on the planet. And that if only everyone would just sit down and listen to him, he could explain this whole unfortunate mess and how he had nothing to do with it. And that demeanor just immediately is something tangible you can pick up on. And I imagine the jurors are doing exactly the same. And in fact, he spent most of the time talking about himself. He went as far back as to high school and talking about his background and how he became the person that he is today, and how he was really this very admirable politician working on behalf of the people to fight against corruption and fraud, and that he really did a good job of it as an administrator. I mean, it is remarkable the amount of time that he took at this most important point in his life. Think about that. The single most important speech he's ever going to give in his life is taking place right now, and he's spending the lion's share of it talking about probate law and what he did as an administrator, instead of explaining to these people why he should not be tied to this crime. I think it was fascinating to watch. I think it was boring at times, but yet still in a fascinating sense. But at the end of the day, I think it was really just insulting to the jury. These fine people have taken time out of their lives to decide a very, very important question. And the most important person they want to hear from is there speaking to them And instead of speaking about Gehrman and how he lost his life and how he, maybe evidence points to him, but he had nothing to do with it, and here are the reasons why, he spent his time talking about himself. I think it's an insult to the jury. I think they will perceive it that way. And I would not be shocked if we have a whip your neck quick conviction in this case when it finally gets in front of the jury. But what do you guys think? I really would like to hear your thoughts. If you did watch the testimony, what was the strangest part to you? What stood out the most? Do you think he should have testified, or did he entirely bury himself with his own testimony? Please let us know in the comments. Donna Adelson was back in court last month for a case management hearing in the upcoming trial for her alleged part in the murder of Dan Markel. Donna Adelson is the fifth person to be arrested in connection to the murder of the former Florida State University law professor who was shot and killed July 18, 2014 in his garage. Her attorneys, Dan Rashbaum of Miami and Robert Morris of Tallahassee, informed Leon Circuit Judge Stephen Everett of several motions they intended to file ahead of trial. One of those motions was filed last week, and it looks to be gaining traction amongst the legal community and courtroom observers. On August 12th, Adelson's defense team filed a motion requesting the court to dismiss the charges against her for what they are calling pre-indictment prosecutorial delay. The 9-page document argues that despite the evidence against Mrs. Adelson remaining largely unchanged, prosecutors made the intentional strategic decision not to charge Mrs. Adelson for almost 8 years. The defense contends that because of this delay, quote, exculpatory documents critical to her defense that the state never saw fit to even obtain were lost to foreseeable document retention policies, causing substantial prejudice to her defense. The motion then asked the court to dismiss the indictment against their client as a violation of Mrs. Adelson's due process rights, or alternatively preclude the prosecution from introducing evidence that Mrs. Adelson can no longer defend herself against. The decision has not yet been issued by the court despite rapidly approaching trial set to begin on September 17th. All right, what's happening here? The first thing to understand is how due process, a constitutional due process, is at play here. One of the things that due process protects us against, anybody who's accused of a crime, it protects us against many things, but one of the things it protects us against is what is called oppressive delay. And we don't see this come up a whole bunch. And the reason for that is that usually there's a built-in mechanism to prevent against pre-indictment, pre-charges being filed, pre-arrest delay. And that is the statute of limitations. We've all heard about this. In every jurisdiction decides those limitations, but in many jurisdictions, for a felony, it can be as much as 5 years. And so if a prosecution cannot get their case together and charge someone with a crime within 5 years of that crime having taken place, that's it. Show over. You took too long. That is a built-in stopgap to prevent prosecutorial delay causing problems, because it does cause problems, as we're going to get into. Now, in the most serious types of crimes, though, murder in particular, many times there is no statute of limitations. That's why we have cold cases. That's why we have murder charges being brought 10, 20, 30, perhaps 40 years later, because there is no statute preventing the prosecution from doing so. But in most cases, that delay is based upon gathering of evidence, not having a solid enough case, witnesses not coming forward, DNA evidence now coming to light decades later, the technology catching up with the investigators and being able to solve a crime. This is different because the defense is arguing here, you had all of the evidence. You had all of the evidence that you did back when Dan Markel was murdered and the investigation that took place shortly thereafter. None of that has changed between then and now when you're charging my client. And that the only reason you delayed was not because you didn't know who your suspect was, not because you were waiting on lab results, not because witnesses had not come forward, not because all of the other reasons that might cause delay, but strategically you decided to wait. And that is why this argument is getting attention. Now, in Florida, the case law that controls says that two elements need to be satisfied in order for the court to do anything about this on Donna Adelson's behalf. One, it is that the delay causes substantial prejudice to a defendant's right to a fair trial. What does that mean? That means that it's not just hypothetical prejudice. It's not, well, had you charged me earlier, I may have gone out and found potential witnesses. I may have gone out and done certain testing. That's hypothetical. That's things that may or may not have taken place. They have to show an actual harm took place, actual substantial prejudice. Somehow you can prove that the delay caused evidence to disappear, witnesses to die, disappear for whatever reason. They talk about preservation of documents. Videotape is a good example. Surveillance video, they don't keep for forever. Sometimes it's 30 days. So things are naturally going to get worse for someone if they're trying to gather evidence if there's a delay. So one, showing that there was actually delay. And we'll get back into whether or not that's satisfied here. But the second prong says, and that delay was the product of bad faith on the part of the state. And this, I think, is going to become the more difficult prong to prove here. But for that first prong, the defense is saying they actually identify some things. They say the SunPass records. You remember, this is that digital device that's on the dashboard of cars in Florida if they want to use the toll roads. And that those records are not preserved for forever. So had she been charged when they had that evidence, when they had all the evidence that they believed they could have charged her, because that's an important point. The defense is saying, you believed everything now that you believed back then. You just didn't charge her back then. Had you charged her back then, we may have been able to get the SunPass records. We may have been able to get the cell phone evidence. We may have been able to get all of this other evidence that it now does not exist because it's not been preserved. Not a bad point, okay? That's a fairly solid point. This does happen. It's provable that they can show that those records no longer exist, and they could say, we are in a worse place now. We have been prejudiced by what the state has done in their delay. It has caused us substantial prejudice. But the second prong, I think, is going to prove more difficult for them. And that is that the state actually acted in bad faith. And the defense points out here that the reason they delayed was, as I've said many times, not because they didn't have enough evidence, not because they didn't believe that she was the one that they were after, but it was a strategic decision that they wanted the case to play out the way that it has. And it has benefited the prosecution, I think. Certain things as far as conversations taking place between Donna Adelson and people who have been charged in this case before and tried, like Charlie Adelson, those conversations, they can record and use because she doesn't have an attorney involved on her behalf. There's other concerns that they're not worried about. They're talking to each other freely. They're both not locked up. It's, I think, been rolled out as powerful and is strategically advantageous for the prosecution, the way that this has all taken place and who they've tried first and then waited to arrest and try next. And that's why everybody was saying, boy, they waited a long time to arrest Donna. Why did they do that? Well, the defense is saying it was strategic. And I tend to agree. Now, the point becomes, though, does strategic mean bad faith? And that's really what they're going to have to show. They're going to have to show that the state not only felt like there was some strategic advantage to them to delay, but that they knew that that would harm and prejudice the defense. And that is where I think it's going to get to be more difficult for them, because they're going to have to show not just, it's going to have to be beyond conjecture. It's going to have to be evidence. It's going to have to be some email exchange, some conversation, some whistleblower willing to come forward and say, yeah, the prosecution delayed because they knew it would hurt Donna Adelson's case, and that's why they waited as long as they did. And they knew they could wait because they were trying other members of her family, and she would stick around and likely have conversations, so that's why they waited. Now, do I think the court is actually going to entertain this? Because, by the way, if those prongs are satisfied, do you know what the remedy is? Dismissal. Case goes away. That's the remedy, according to the case law in Florida. What I think the court is going to do, though, in a case of this magnitude, is likely split the baby, as it were. And the defense even asked for this remedy. The defense says, if you're not willing to dismiss this case, then at least prevent the prosecution from using evidence that we don't have an ability to defend ourselves on because it's been lost. So if the court even goes that far, the court could very well likely find there was delay. The delay did cause prejudice, but there was no bad faith in it. That's probably what's going to be the decision of the court. But even if the court says, you know what, I do believe there was a little bit of shenanigans, a little bit of hanky-panky taking place with the prosecution as far as they handled this. The most I'm going to do, though, is prevent you from using the SunPass device or whatever it is, cell phone evidence. But I imagine it won't be something so crippling to the prosecution's case that they can't proceed forward. What do you think, though? What do you guys think? I'm always curious. Do you think the defense actually has a point here? Am I getting them all worked up over absolutely nothing? And is this just more defense game of three-card Monte trying to fool the prosecution here on a case where somebody is very obviously guilty? I know you guys have a lot of strong thoughts about this case, and I'd like to hear them in the comments. Before we dive into the other cases making headlines this week, I only want to ask this one very small favor from you, and that is, if you haven't already, please take a moment to subscribe to this channel. And if you have, we thank you so much. Please go tell a friend. It really helps us out immensely in being able to grow this channel, which includes things like our brand new membership program. And if you haven't heard about that and want to learn more about it, please hit the join button on our YouTube page or the link in the description on this video to hear all of the details. We are continuing to be blown away and impressed with the response and feedback that we get from all of you, and we look forward to providing you all with more and more content every single week. And don't forget to check out Courtroom Confidential as a podcast and join our community on all major podcast platforms. All right, also making headlines this week, Sean Finnegan, the Tennessee man convicted in Jennifer Paxton's gruesome murder in late 2019, was sentenced to death Wednesday morning. On Monday, the same 12 jurors found Finnegan, who had lived in Oak Ridge, guilty of first-degree murder, aggravated rape, aggravated kidnapping, and abuse of a corpse, amongst several other charges. Prosecutors said Paxton's body had been kept for about 8 months in a freezer in the bedroom, but was moved quickly by Finnegan to a place under his bed before police arrived to search for the body, which was found in early August 2020. They believe she was strangled to death in December of 2019. Finnegan's girlfriend, 26-year-old Rebecca Dishman, told officers that Finnegan killed Paxton, strangling her with string over a lengthy period of time, taking breaks and stopping to smoke. Arguing for the death sentence, prosecutor Kevin Allen told jurors Sean Finnegan must be given the same amount of mercy he gave Jennifer Paxton. Nearly 10 months after the death of Matthew Perry, the long simmering investigation into the ketamine that killed him came dramatically into public view with the announcement that 5 people had been charged with having roles in the overdose of the beloved Friends star. Recent reports suggested indictments might be imminent, but few outsiders knew how wide-ranging the prosecution would be, reaching much further than previous cases stemming from celebrity overdoses. An indictment unsealed Thursday alleges Perry turned to Los Angeles doctor Salvador Plasencia when his regular doctors refused to give him more ketamine. Prosecutors allege Plasencia cashed in on Perry's desperation and addiction, getting him to pay $55,000 in cash for large amounts of the drug in the 2 months before his death. Prosecutors allege Jasveen Singha, whom they describe as a drug dealer known to customers as the ketamine queen, provided the doses of the drug that actually killed Perry, injected into the actor by Perry's live-in personal assistant, Kenneth Iwamasa, with syringes supplied by Plasencia. Trial is currently set for October 8th, though that is likely to change. Alec Murdaugh, the disgraced lawyer convicted of murdering his wife and son, may get a new murder trial after South Carolina's highest court agreed to hear his appeal over a claim of jury tampering. A jury found Murdaugh guilty of both murders after a 6-week-long trial in March of 2023, and he was sentenced to life in prison. His lawyers have since argued that a court clerk tampered with the jury, telling them to not trust Murdaugh's testimony and to speed up the verdict. In their filing to the South Carolina Supreme Court, Murdaugh's lawyers argued that there was, quote, an irrebuttable presumption of prejudice when a state official secretly advocates a guilty verdict. In April, Murdaugh was sentenced to 40 years in prison on a separate trial for federal financial crimes. He is also serving 27 years for nearly 24 state financial charges relating to fraud and money laundering. Massachusetts woman Christine Ricci, convicted of fatally stabbing her husband, Boston firefighter Michael Ricci, has been sentenced to life in prison with the possibility of parole after serving 26 years. At the time of the deadly incident, Ricci claimed her husband was in the throes of a manic episode and became violent, causing her to brandish a kitchen knife in an attempt to scare the man. Earlier this month, after only 3 hours of deliberation, a jury came back with a verdict of guilty on second-degree murder. Before we get to what's on the docket for next week, I wanted to take this time to thank you all for your support. The love from our growing community has been amazing, but we wanted to give a very special shout out to 1910 House for their wonderful review on Apple Podcasts, and to our new members, Tanya Hurley, 4367, and Farm Girl 31794 for their kind words on YouTube. Keep them coming. We always highly appreciate your feedback. And tell us where you're from. We are always thrilled to hear about our growing international community. On the docket for next week, Kouri Richins is scheduled to appear in a multi-day preliminary hearing starting Monday morning, August 26. She faces a first-degree felony aggravated murder charge and attempted criminal homicide, among other charges of drug distribution, fraud, and forgery in connection to the death of her husband, Eric Richins. Wade Wilson, the Florida man convicted of killing 2 Cape Coral women, will be back in court for sentencing on Tuesday, August 27th. Wilson was convicted on June 12th for the murders of Christine Melton and Diane Ruiz. On June 25th, the jury in Wilson's trial voted in favor of recommending the death penalty for each of the murders. It was New Year's Day 2023 in Cohasset, a wealthy seaside enclave 40 minutes south of Boston along the Massachusetts Bay. Wife and mother of 3, Anna Walshe, was expected to commute to D.C., where she worked as a regional general manager for a real estate firm. She would never make it to the nation's capital. Hours after she celebrated New Year's Eve with friends and family would be the last time the petite brunette would ever be seen alive. Less than a month later, Brian Walshe, Anna's husband of 8 years, would be arrested and charged with her murder. To this day, her body has never been located. Please join me this coming Tuesday as we dive into this case for another episode in our special series, Courtroom Confidential Case Notes. That is it for us this week, folks. I am your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a wonderful weekend, and I hope to see you again next week for another episode of Courtroom Confidential.